panel. In the following video, we will go over the steps to drafting a joint case conference report or a JCCR. In exempted cases, the JCCR is a required document that the parties file together after holding their early case conference. The JCCR tells the court that the parties had a meet and confer, and that they exchanged documents and witness information, or that they served their initial disclosures. It also establishes discovery deadlines, which the court will enforce, and it informs the court that both sides are cooperating and moving the case toward resolution. In some cases, if the parties cannot agree on the report, each side may file an individual case conference report. But this is not very common. Again, know the rules for your county and state. As previously discussed in another video, the parties must meet and confer within 30 days after defendant files their answer. And then the joint case conference report will be filed within 30 days after the case conference is held. See my other video regarding scheduling and noticing the early case conference. Okay, so before you start drafting the JCCR, get the discovery time periods agreed upon from your attorney. It'll usually be 12 months, but on occasion it can be 18 months. Also, have the complaint and the answer open, as you will need some of the information contained in them. And as previously discussed, get the caption, information, the name of the parties, the case number, department number, and the appropriate court from a prior document or from the complaint. Okay. And the title of this document is Joint Case Conference Report. So the first page must always contain this information: attorney information, parties information, the court, case number, department number, and the title of the report. And there's really no opening paragraph. Just select or check yes or no on these first questions. Okay, section 1 now is going to be the proceedings prior to the case conference report. So in subheadings A through C, you're going to enter the date the complaint was filed and the date the request for exemption, the date of the answer was filed, and the date that the request for exemption or petition for exemption was filed, and the date that it was granted. Okay, on to subsection D. Here you will enter the information, the date that the early case conference was held, and who attended. So just fill in the blanks, the name of the attorney that appeared on behalf of plaintiff, and enter the plaintiff's name, and the name of the attorney and their law firm that appeared on behalf of the defendant, and enter defendant's name. Okay, section 2 is going to be regarding the nature of the action or the lawsuit. In subsection A, enter a brief description of the action, the date of the incident, and what occurred. It's just a small summary. Fill in the blanks. In subheading B, you're going to make a numbered list, as in here, of plaintiff's claims for relief. You can find this on your complaint. This is where you will need a copy of the complaint, and it'll be in the prayer section at the end of the document. Okay, so these are just basic here, 1 through 5. In subsection C, you're going to open up defendant's answer to get defendant's affirmative defenses, and just enter whatever their affirmative defenses are, as in first affirmative defense, second, third, and so on. Enter all of them. Sometimes they have 10 or more. So just check the answer. In section 3 is really a standard paragraph, and you can revise it as necessary according to your law firm rules. Section 4 is regarding the list of documents disclosed. So each party should have already served their initial disclosures by this time, or around the time of the early case conference. You can enter the date that the plaintiff served their initial disclosures, or the date that they will be provided by. And same thing for defendants. Enter the date the defendants served their initial disclosures, or the date that they are planning on serving them. Okay, in section 5 is going to be a list of the persons identified by each person or witnesses. So this information was also provided with initial disclosures. Enter the date the initial disclosures were served, or the date that they will be served or provided. Okay, and then section 6 is going to be the discovery plan. This will include a plan discovery that still needs to be done. In subheading A, enter any changes that should be made in the timing form or requirements. Usually it'll be none, okay? But again, check your law office rules. Subsection B is, this is also standard language. Usually it's liability, causation, and damages on which discovery may be needed. Okay, subsection D, E, and F, you will enter yes, no, yes or no, none, or those are pretty self-explanatory. And here in F, enter the rule number for your county or state. In subheading G, you will enter the estimated time needed for trial, usually 5 to 7 days or whatever it was agreed upon. Okay, section 7 now is regarding discovery and motion dates. This is where you will also need a date calculator. Okay, so I have a date calculator that I usually open, and it's very helpful, especially when you're pressed for time. So the date calculator, I will open a copy of it. Here you can enter whatever date, and then you can add or subtract. It's self-explanatory, so this is very helpful. Okay, and I have a link to this date calculator in the description. Okay, again, you will get the discovery time from your attorney. Okay, so you will, in the date calculator, you will add 12 months from the date of the early case conference, and you will enter that date here. Okay, so if the early case conference was held January 1st, 2020, it most likely discovery will close in 12 months or January 1st, 2021. We're not in 2021, by the way. It's just an example. And from that date, you will fill in these other dates, okay? So the final date to file motions and amend pleadings is going to be not later than 90 days before the close of discovery. Use your calculator. Okay, and then final expert disclosures, initial expert disclosures, enter that date here. It's going, again, it's going to be no